rise. Court of Appeals, Division 1 is now in session.
Please be seated. We're on the record now in case number CV14-0649, in re the marriage of Jane Bacchus and Larry A. Bacchus. This is the time set for oral argument. Counsel, you each have 20 minutes to present your case. Counsel for the appellant, you can set aside some time for rebuttal. Just let us know when you come up to the podium. You can keep track of the time on the podium. There's a clock there. We've read the briefs. We're very familiar with the issues, so keep that in mind when you make your presentation. I will advise you that the proceedings are being audio and video recorded, so it'll be uploaded to our website in a couple days, and so people can view that if they wish to do so. Is it Mr. Middlebrook?
Yes, Your Honor.
All right, your argument?
There's at least two things that everybody can agree to, and that is, one, the original decree contained mistakes, and two, the original decree was set aside because it had contained irreconcilable and inextricable provisions related to spousal maintenance and property equalization or property. So bearing that in mind, that those two issues are irrefutable, and the reason they're irrefutable is the latter, or the set-aside order, was never appealed by the appellee, and that is not subject to review by this court. So the only trial court order that's actually before the court today is whether or not this amended decree is a legitimate pleading. And it's an illegitimate pleading if, in fact, it's determined that the original decree was set aside and therefore the decree in which it was to amend never existed or became a... Yes, Your Honor.
Yeah, excuse me for interrupting, but I just wanted to focus on the procedural question that's prompted by your preciseness there a moment ago. After the original decree, 5 months later, then husband files a motion to set aside. The court grants an amended decree. And then husband files a motion for clarification, motion for new trial. Is that right?
That's correct, Your Honor.
That's the motion you're claiming that we're here. The denial of that motion is what you're claiming we're here on?
Well, I believe that we're here on the latter two rulings. The first is that we never got a motion to, well, the motion to clarify was denied, and the motion for new trial was denied because we believe that there were substantive changes that was created in the amended decree that should never have occurred.
Right.
But the original motion that we're not before the court on is the whether or not the original decree should have been set aside. That was granted by the trial court.
Right. Nobody's complaining about that to us at this point.
Correct.
Okay.
And so, therefore, do you really have, are we even procedurally really talking about whether this amended decree we should even get into the substantive provisions of it? Because there really was, in a relation back under Rule 34, you can't relate back to a decree or to a pleading that has been set aside. So that's the basic issue about the amendment to the decree. The substantive provisions within
But your argument is, if I understand correctly, is that the amended decree has some significant problems.
The amended decree continues with the significant problems the original decree provided, and simply put, where we really can see that is where the amended decree continues to provide wife spousal maintenance only, but turns it on its head and says, by the way, she's getting these property interests in husband's pension plans, Social Security benefits that she was never supposed to receive in the first place. And we're not even going to make a deduction for those when we're going to take out this property. I mean, remember, the original decree and the original agreement, I believe, by the parties was that wife was not to receive any pension interests, nor but in lieu of not receiving those pension interests, she was to receive spousal maintenance. The problem is the partial property settlement agreement called this thing a creature that cannot exist, which was spousal maintenance / equalization payment.
Isn't there also some impropriety, though, in calling spousal maintenance something that clearly isn't, such that in this case your client gets a tax benefit to which he wouldn't be entitled?
In this case, he would get, well, that's as far as tax benefits, that becomes an interesting issue from this perspective. If the $3,300 is spousal maintenance, he gets to write it off as taxes.
Correct, but if this were a true quadro, he would get no tax benefit from distributions to wife, and isn't he inflating, possibly contrary to law, his tax benefit by calling this something it's not?
Well, certainly if he had drafted this agreement, which he did not, but that would certainly be something to consider as to what benefits he may have gotten under this particular agreement.
I'm just seeing that there are problems that run both ways, it seems.
Correct. I agree. And under the present argument that's before the court in her answering brief, the wife is basically claiming, hey, look, all we're really trying to do with these domestic relation orders and with granting her this interest in these pension plans is to really kind of just get this payment. But I think all of us can agree pension plans do not pay spousal maintenance. They pay property interests. And carefully reading of the amended decree continues with the exact same problem that the original decree had, and that was that in one hand, the wife was saying she gets no property interest in these pensions, and literally several paragraphs later it's saying we're going to give her domestic relation orders to secure property interests. Again, and according to your question too, really kind of a real problem, especially when we come to the tax code, but also when you just simply look at family law issues, you have spousal maintenance determined under certain statutory factors, and you have property interests, which are immediate vested rights. And
should we be influenced in trying to look at this and analyze this? Should we be influenced at all by the fact that husband originally agreed to this?
You know, that is a problem. I agree. I suppose that the simple argument could be made, and certainly something that I have to concede is, but Brian, it's an agreement. True, but it's an illegal agreement. For example, we know, and the problem is it's really this inextricable provision problem that makes the entire agreement problematic, because when you look at it, you have spousal maintenance equalization. I mean, that's literally what it's called in the partial property settlement agreement that was subsequently became merged and incorporated into the original decree, stating that what we're going to do here is we're going to basically combine all this together and then try to flesh it out. Well, the problem is that original provisions, I don't want to use the word illegal from like the criminal sense, but I believe illegitimate from the legal sense from this perspective is you can't have both. You can have spousal maintenance.
Sure.
Wife will be paid spousal maintenance,
yeah,
but she can't be paid both at the same time that you're saying she's getting no property interest. Therein lies, I believe, the fundamental problem with the original decree.
And the amended decree.
And subsequently the amended decree as well.
What is illegal about that?
I'm sorry?
What is illegal, or whatever term we want to use? What's improper about that?
What's improper about the combination is this. One is we have a tax code issue, so that's one, but we also have, if they were separated out, in other words, if as the original decree, what makes it improper is the original intent of the parties was, I think everybody would agree, would be wife will get no property interests. But then she's getting property interests, which are exactly contrary to what I believe the parties intended under the partial property settlement agreement as well as the subsequent original decree. And so you can't do both. You can't, in one hand, tell her you're getting no property interests and then turn around and give her property interests. Nor can you go to the husband and say she's not getting any property interests and then turn around and give her property interests. There's also another issue about that. From this perspective, spousal maintenance terminates on remarriage or death.
So, this all seems somewhat anomalous to me or unusual to me because husband is arguing that we should set this aside because wife's property interests aren't properly protected, but wife is happy with it, I guess.
Well, wife is happy with it. The reason husband's not happy with it from that perspective is this, is if she has no property interests, if she dies, his spousal maintenance obligation terminates. But with the domestic relation orders, if she dies, her property interest continues, and then her heirs or whomever would inherit that property interest, and he would there be deprived of getting that pension benefit, those pension benefits. And that goes along with the Social Security issue, which really has more or less been conceded. It's just, what do you do with that Social Security interest that was divided, again, illegally under federal law and subject to division? So the problem is this was not only
Illegally and mathematically a little weird as well.
Precisely. And therein lies the problem. It's almost like you're throwing in bad meat into the stew and then saying, well, let's now go back and try to take the meat out and let's have a palatable meal. You can't do it.
It's like trying to call a tail a dog's leg, right, John?
Something
Oh,
like
boy.
that, yeah. So I mean, it's not just the one provision, but it's almost all of the provisions that are so intertwined and irreconcilable that I believe that's why the trial court said, I'm going to set this original decree aside.
And the trial court tried to fix it.
The trial court, I think in good faith, tried to fix it. The problem is it perpetuated the exact same problem, almost the exact same problem. And it created a new one, because what it did in doing so is now it said wife, it completely removed the language that wife was not to get property interest, and now said you're getting spousal maintenance and you're getting a property interest, and these interests will not terminate on your remarriage or death. These were substantive changes.
Yeah. Do our Superior Court judges have an obligation to, when ruling on division of property, to evaluate whether each spouse has been reasonably fairly dealt with?
25-317 specifically provides that a trial court must determine whether these provisions are fair. Actually, the way it words is whether it's unfair. And
Which is
so,
more challenging in a consent decree context, wouldn't you agree? I mean, it's difficult for a trial court to look at a negotiated document that both parties with counsel have signed off on and say, this is not fair to one side or the other.
in the
You can
real world, I
understand
agree.
how these errors, well, I don't know if you can understand how the first errors occurred, but I can understand how the court went along with the errors and created the issue we have now.
Yeah, in the real world, Judge, I agree, unless they're really given some type of analysis as to each asset, that kind of thing, earning capacity of each spouse, et cetera. It's almost impossible for a judge really to make that. And at some level, to be fair here, has to rely on the parties' intent, their representations by counsel, et cetera, to determine what's fair or not. And I think most trial courts, in the real world, typically will do that and say, look, if you guys bring this to me and you think it's fair, that's fine. But let's remember, this was challenged throughout. Wife's represented by counsel, husband is not. So I will concede, and even though that's not an umbrella under which husband could hide, that may have been part of the problem here is that he was not represented by counsel, and there wasn't enough of analysis done, not only in the original partial property settlement agreement, the original decree, and then subsequently, and obviously by them in the amended decree, the objections were made.
How would you have us solve this?
You know, Judge, I really think that we have to go back to what's already been solved, and that is that these provisions are irreconcilable and inextricable. And so as a result, we need to start over and figure out where to go from here, because there's so much interweaving with the Social Security benefits, the pension plans. What was intended there? Did the parties mean to, okay, you're going to get $3,300 and that's it? Or was it part of, you're getting $3,300 because this is part of your property? No. And we just don't know that.
Has there been any evidentiary hearing?
There's been no evidentiary hearings on the subject as to whether or not, or what was behind one, the party's intent, but two, what is an equitable division of property? What are your property rights in these particular pension plans, et cetera? Which I think is a critical issue here, too, is because one of the issues is, well, you never ask for findings of fact, conclusions of law. It's kind of an impossible thing to do where there's been no evidentiary hearings.
If we vacate the trial court's denial of your motion for clarification / new trial and vacate the amended decree, then what happens?
Then we're at the start over point, which is, I do genuinely believe that, as opposed to going through and trying to save certain provisions, I do believe that that's unfortunately where we must be because of just how much was intertwined here.
We'll probably ask the other side the same question if we have.
I'll reserve the rest of my time. Thank you, Your Honor.
Thank you, counsel.
May it please the court, my name is Edward Walneck. I'm with the law firm of Aspie, Watkins, and Diesel. I'm here on behalf of the petitioner and the appellee, Jane Baucus. We certainly don't necessarily agree with all the presentation of the facts presented by the appellant, and I'll get to those during the presentation or during the questions from your honors. But I think the focus of this case needs to be on the trial court. The trial court used its sound discretion to fix errors that were in the original decree. And the argument is simply this. Admittedly, there were errors. There were errors by my side. There was errors by the appellant. There are errors additionally by the trial court. But this is a classic case of why Rule 85 of the Arizona Rules of Family Law Procedure and as well as Rule 60 of the Arizona Rules of Civil Procedure exists.
But were all necessary errors corrected in the amended decree?
We would contend that consistent with the original agreements of the parties, and the original agreement of the parties was that Ms. Baucus would be receiving $3,300. And to this day, she only receives $3,300 total. And it's consistent with that original agreement that was put in place.
We might debate philosophically whether we should give greater deference to the agreements of parties when we have other rules and principles that are also applicable. But we are living in a world, are we not, in this context whereby the Superior Court has a responsibility to review the division of assets.
And indeed, the second time around when they put in place the amended decree and their findings that they put out, and on the record, I shouldn't say the findings, but on the record, they clearly stated that they reviewed the record closely. They looked over all of the facts and in the case, and they quite clearly stated that that problems with the decree were errors and omissions that needed to be fixed and lack of clarity. And that's what it went by and fixed. And I think the other issue that we all need to be closely paying attention to is that this is part of this is a non-modifiable spousal maintenance issue. And I think the elephant in the room here is the fact that appellant's not happy with the agreement that was made. And as I think you can tell from the briefs, every legal argument in the world has been thrown up against the wall to see what sticks. This is an issue of trying to get another bite at the apple. And frankly, I think this is about the third bite at the apple, in which he's trying to get out of a previous agreement that was agreed to. And as was admitted by the other side just a minute ago, this was what was agreed to at the very beginning.
Do you agree with Mr. Middlebrook that there's been no evidentiary hearing?
I agree that there has not been an evidentiary.
Does that matter?
I believe it does not, because this is within the sound discretion of the trial court.
The court is still able to take facts given that are undisputed by the parties and assess those and evaluate those.
Correct. And that's what happened in this case. And you'll see in our briefs, we go over this issue at length, that the trial court had the choice, and it's within their discretion of whether they want to have an evidentiary hearing. And as they stated, this case has been pleaded ad nauseum, frankly. I mean, there is a lot of information out there that both parties went through this agreement. Not only was the original decree put in place, and then 5 months later, there was the motion to set aside, there was motions with that, and then after that, another motion for clarification and new trial. So all the while, I would hope that appellant would not contend that they were prejudiced in these proceedings in any way, because they had an opportunity to file several pleadings along the way. And that brings up the other issue that was mentioned by your honors, is that the appellants did not ever request a findings of fact or conclusions of law. And the law quite specifically states that when these are not put in place, that, and this is a quote, must assume trial court found every fact necessary to support its judgment and must affirm any reasonable construction of the evidence justifying the decision. This is in Stevens v. Stevens.
But that, go ahead.
Go ahead, Your Honor.
That wouldn't apply to questions of law, and I want to get back to a question Judge Gimmel asked about continuing errors in the amended decree, because it seems there are some. Let me give you one example. I know you say the practical effect is wife still receiving $3,300 a month, but the amended decree clearly contemplates that part of that $3,300 will come from the quadros, but the quadros were set aside after the court set aside the consent decree. So we've got some they're not niceties, they're huge legal gaps in the effect of the amended decree. How can we let that stand, even though you say, well, wife's still getting $3,300?
And I would retort, and you can ask me a follow-up question if I'm not able to fully answer this. I think the important situation right here is in her sum of her $3,300, she is in fact receiving money from Orange County, and she is receiving money from Boeing.
But those quadros were set aside by court order, and so I understand that's the status quo, but that's not a very, that's a precarious status quo from a legal perspective, and it's an error that shouldn't exist.
Yeah, and our contention is that it goes back to the issue of non-modifiable spousal maintenance, and I realize that this is kind of a sausage making issue, and I would go back to the trial court discretion in this, and that we're using the abuse of discretion standard here. When they were in this and looking at this and looking at the previous agreements of the parties, which is undisputable that she was going to be paid this $3,300, it was trying to figure out the sources that it would come from. And in that process, they figured out that some of it would come from Orange County and some of it would come from Boeing, as well as a cash payment. And that is the situation that exists to this day. And I recognize your concern, Your Honor, with how these quadros got set effect. My understanding in the amended consent decree is I think there is wording that perhaps gives effects to those quadros when it's re-amended. If I have a misunderstanding of that, you can correct me, but that's my understanding, is when the court went back and they put just Boeing and Orange County, they were giving effect to the quadros that were in place already.
The court counted the $220.60 from one and $1,173.92 from the other, if I'm reading this correctly.
That's correct. And
is that the language you're referring to?
Yes, that's what I'm agreeing with that. And
I'm not entirely sure that breathes life into quadros set aside. Mm-hmm. But I guess I'm also concerned about, even the amended decree refers to the $3,300 as in for spousal maintenance. Mm-hmm. But part of it is community property, not technically spousal maintenance. So how can can calling it spousal maintenance make it spousal maintenance?
And our contention there is that was the contemplation of both parties when they sat down and made the agreement, was how are we going to get to $3,300? And the terms may have not been perfect. I can admit that, but we can probably agree they weren't. That said, I think what's important is the public policy on this issue is that this was an agreement by both parties, and the effect of what the appellant's asking for is to basically blow up this agreement that was made over 3 years ago, has had countless amounts of litigation involving it, but it all goes back to the fundamental principle that this was originally agreed upon by the parties, and the appellant is unhappy with what that agreement is, and now is trying to find every little hole in the dike to try to burst it open. All the while, we admit when the original decree was made, there were issues. We went back, and the appellant and ourselves and the trial court went back to try to fix it. And our contention is that it's fixed to the point where she is getting paid her $3,300 that is quite clearly stated in the decree that she's supposed to get paid. I think the wording and how you get to that, I think you've brought up the issues with that. But I think what's important to say is that, this was the agreement, that she would get paid this amount of money, and the effect that the appellants would like to get at is to get around it. And when we look at the broader issues in this case, there are really, I believe, three high hurdles that the appellants have to overcome. And first is the deference to the trial court. The trial court, on the second go around on the amended pleading, or the amended consent decree, looked over it very carefully. And they are given deference on whether to grant or deny the new trial. And we believe that standard would be abuse of discretion. And we don't think that the standard, the amount of abuse is there to warrant overturning that motion, or that finding, excuse me. And then second, as I mentioned before, no findings of facts and law. I think the appellant has stated earlier that that was a situation where, it's hard to roll back the clock and do it now, and they didn't know. But they are the ones that have the burden when they appeal cases. It is their burden to prove to you that the decisions of the trial court need to be overturned. And without that record there, Your Honors, there is an important deference that needs to be paid to the trial court and their findings. And
Even if it's a legal error?
My contention is that these were not necessarily legal errors.
What do you mean not necessarily legal
Well,
errors? I don't know what you mean.
Sorry, Your Honor. Let me be clear. That the errors in here were grammatical and lack of clarity. These were unintended errors. These were omissions.
We're talking about the original or the amendment?
I'm talking about the original and what was done in there. And then if Your Honors, I think that you kind of asked at the end if we are going to fashion to move this back. Those are the types of errors that are still in place here. They're grammatical errors and they're clarity errors, because
Clarity errors are different from clerical errors. I mean, I would agree with you that transposing petitioner and respondent is a clerical error, but I can't imagine any of these other issues could be categorized as clerical, and clarity errors aren't clerical errors. So I think I don't agree with you on anything except petitioner and respondent.
Okay. So going back to the issue of where the funds are coming from, because I really think that's at the heart of this issue of when we're looking at what kind of creates that $3,300. And the error, and I would say I would say judicial oversight right here on this part of allowing that to go through if that's the issue. And if we certainly don't want to concede that the amended decree has a fatal error in it. We believe it doesn't. We believe that it works as written, and the practical effect that it has is it allows the original agreement to go forward. However, if the contention of this court is that there are errors in there, that it's of a sort that does not mean that the whole entire the amended consent decree needs to be imploded, and that it would be remanded back to the trial court to fix those errors.
What do you mean by that, Mr. Walnick? I mean, the issues are, nobody's saying, I guess, that every provision has to be vacated or reversed. It's the spousal maintenance and the property settlement. Do you see any legal errors that the court made in the amended decree regarding the spousal maintenance and the property awards.
I do think there's a conflation of the two that needed to not happen.
Okay.
And
But, so, I mean, what's the upshot of that?
I think the upshot of this is that I go back to the first argument is simply this, is that at the very beginning of this, that there was an agreement that she would be paid $3,300 as spousal maintenance. The parties came together and tried to reconcile those differences. Okay, sorry, Your Honor.
No, that's okay. No need to apologize. I'm just trying to understand your argument a little bit better. We would review legal error de novo, right?
That's correct.
And if the trial court made a legal error on either the spousal maintenance or the community property or property disposition, why would an agreement that was illegal be something a court shouldn't review? Isn't that what?
I think I need to
supposed to
roll
do?
myself back here, Your Honor. I may have misunderstood or misspoke when I spoke this earlier. I was misunderstanding the question. I think it's important that I state quite clearly on the record on this issue. We don't view it as illegal. We do not view it as illegal. This is an issue of judicial deference and abuse of discretion.
I guess I'm puzzled on a practical level. If your client acknowledges she's entitled to $3,300 a month, why does she care? Why does she insist on it being spousal maintenance, which seems to disadvantage her in terms of tax consequences, in terms of it would terminate if there's death or remarriage? I guess I'm, as a practical matter, not understanding why there's so much conflict when it seems the parties agree on the bottom line.
I agree with this, and this has been part of the problem in the case in general, and why I'm so hesitant, and I'm really requesting this court not to blow up this agreement, is that when the agreement was originally put in place and when the problems were discovered, frankly, all this stuff could have been probably solved with a phone call. But that was not the approach taken. And hindsight's 20/20, and we wish we could have had the other party be willing to fix it. But however, when the agreement was made, it was made with the idea of trying to get to that amount. That was $3,300. And at the time that the agreement was made, the idea was non-modifiable spousal maintenance to guarantee and make sure that she would receive that amount in total.
So, Mr. Walnut, if we send it back and had the court clarify this and make, you could still arrive at a decree that has $3,300 in combination of property award and spousal maintenance, you oppose that?
It would not be our first preference. We would prefer to just keep this as is. But
The problem is you don't know what you're going to get.
Exactly. And that, you hit it right on the head, Your Honor. We send it back. We don't know what's going to happen. And we're afraid that, in a sense, the appellant has not hid their cards. They want to get rid of this completely. And if we send it back, we don't know. And the practical and policy effects are very important in this part, where we're basically erasing an agreement that had been put on the books. And
it's extremely rare when he hits it right on the head. So I just want to note that.
But
It is. Make a note, somebody.
But to go back to your question, if it's sent back to the court, I would think it would need to be sent with explicit instructions under Rule 85 of how it would be fixed, and the issues that you've pointed out today. That said, for all of its issues that it may have, we strongly contend that the agreement, as written, still owes judicial deference, and still, when we look at it at a complete picture, as a whole, it's meeting with the original agreement of the parties to give Ms. Bacchus $3,300. And I think the other thing that we have to see right here too is that when we kind of analyze the mistakes that were in the original decree versus the amended decree, the court's already demonstrated that it can go back and it can fix things. And it fixed several provisions already. And it did it well within Arizona law, as well as the Arizona rules of family law and procedure. And I guess I want to sum this up today, Your Honor, if you have any other questions. If you don't, I want to sum this up as the importance of, within the context, I think the context needs to be closely paid attention to. In the context of the situation, this was two parties over 3 years ago that came together and made this agreement. And there's undisputed that they made this agreement. Mistakes were made at the original decree level. 5 months later, the husband filed a motion. Did not get the result he wanted, continued on with another motion for new trial. Today, before is the amended decree that you have before you. It still is effectuating the original agreement that was put in place over 3 years ago, and the effects of rolling it back and getting rid of it will be devastating for my client. And thank you for your considerations, Your Honor.
Thank you, counsel. Mr. Middlebrook?
The assumption made in the argument is that the $3,300 was to be spousal maintenance only. The partial property settlement agreement specifically provides that the $3,300 is comprised of spousal maintenance and equalization payment. Therein lies the fundamental issue as to what the original intent of the parties were. Because if, in fact, as both parties have argued, when you go through the opening briefs, the answering briefs, and the reply, is this: both parties have drawn and withdrawn certain portions as for example, spousal maintenance versus a property interest. In my opening brief, I did that very simply by taking the amount of the payments under the pensions, the amount of the 30% allocated to wife under the Social Security benefits, which works out to about roughly $1,300. I think it's like $1,274 is the combination of those payments. So the issue is not, was the $3,300 spousal maintenance only. That's what that whole argument was about, is, hey, let's keep the $3,300 without really getting into, well, wait a second, the $3,300 is made up not only of non-modifiable spousal maintenance, but this other thing that should have never really been thrown in here of an equalization payment of at least $1,274. So even when you read their answering brief, they concede that wife is going to receive payments, and again, judges, I apologize, but I'm going to approximate here, that she would receive approximate payments from the pension plan of about $1,200. So if she's receiving that approximate benefit through these DROs, therein really is a concession in the exact problem that we're faced with, because the amended decree says it's spousal maintenance only, and then turns around and gives her a property interest and says, but you're going to receive these payments from the pension plan without any qualifications as to remarriage or termination on death.
And hadn't it vacated the quadros in the amended decree?
The quadros they reinstated them, because what happened was, remember, the decree's been set aside along with the DROs and along with the contempt orders, where wife had gone in and said, hey, when husband did deduct these payments, he's held in contempt by the trial court for deducting the amount she was to receive from the pension plans.
But although the amended decree talks about a stream of income from the quadros, I don't see any place where it reinstated the quadros. It looks like if the pension funds were to look for a quadro, it's been set aside.
As I recall, the specific provision under the amended decree basically states wife will receive a property interest.
That's not a quadro.
It's not a quadro, but the way that those property interests are, I can only tell you, typically granted is when a domestic relation order is issued. So, I mean, I think it would be easy for if this court upholds the amended decree, to present DROs or domestic relation orders saying, okay, we're going to divide these pension plans. The other problem is, if she's receiving this property interest even without the DROs, again, we still have the termination on death and termination on remarriage, that those are not subject to that property interest is not subject to that termination, and yet all of us agree that it's absolutely subject to termination under Arizona law. The spousal maintenance provision is absolutely terminated on remarriage or death, and that just doesn't exist under the amended decree. So I'm
Why-
sorry.
Why should that matter to us? I mean, there are all kinds of legal documents every day in every kind of situation where somebody leaves something on the table, we might say, from a negotiation standpoint.
Well,
Isn't the most important thing here that this, under the amended decree, some of the egregious errors in the original decree have been eliminated, and it is carrying out the intent of the parties as they originally agreed.
Well, if it's carrying out the original intent of the parties, that it assumes that that's wife's intent to get $3,300, not necessarily husband's intent.
Well, he agreed
If I'm
with
going to
that.
give her this property interest, which included Social Security benefits, which should have never been divided. And again, it's a misstatement of law, but that is what happened.
Yes.
But also, let's assume, and I will be a cynic and a little dark here, but let's assume husband's going, I'm going to outlive her. And I'm going to outlive her by a lot. So I would rather give her spousal maintenance because I think her health is really bad and it terminates on death. And then I get my entire pension. So that's not what will happen under the present situation. So you might say husband's bet that wife will die earlier than he is lost because she's getting this property interest now. And it does not terminate. So that's why it's significant to husband. And that's contained in the original decree. But I agree. I think part of the real problem here is this merging. And this whole non-modifiability. I believe that's a non-issue, and I just want to just simply state with my few seconds left, and that's this. What's going on there, you have to go back to that partial property settlement agreement, calls this payment a spousal maintenance / equalization payment. Within that payment is the first of all, in the original one is the domestic relation orders, dividing the pension plans, but it's clearly given wife this proprietary interest, which in one provision of the decree says she's not going to get a proprietary interest. But it also includes the Social Security. So the problem is when you take these out, you're not modifying spousal maintenance, you're deducting property that wife should not have received. So it's not an issue of is the whole 3,300 non-modifiable, at least under the original decree and its partial agreement that was merged into it, but it's whether or not when property is deducted, that's the issue as to why these payments should be reduced. And I think that's what's contrary to wife's position. She on one hand says, I agree that it should have never been included, but I want to keep the money from it.
If it was true spousal maintenance, all of it, let's assume, then it would be non-modifiable.
If the entire 3,300 was spousal maintenance and husband agreed as he did that it was non-modifiable, it would be non-modifiable.
Yeah, husband agreed, they told the court they agree, and the court orders it, then that would be non-modifiable if it was all spousal maintenance.
Correct.
All right, thank you, counsel. We'll take this matter under advisement and we'll issue a written decision in due course. Court's in recess.